First on our agenda this morning is hearing from Carol McMahon Bowles. And is Carol is on the phone. We want to thank Carol for joining us. Nebraska adopted, well, Carol, would you mind if I just have you tell us your background and your experience and why you think we invited you to talk to us today?
Yeah, I'd be glad to.
Thank you.
What happened in Nebraska sort of began back in 2006 when the Bar Association was advocating to have Nebraska adopt MCLE requirements. We were one of the last of 5 states in the country that didn't have mandatory continuing legal education requirements. And the court had already by that time removed discipline from NSBA, from our local bar association, and put it into the Supreme Court. They were concerned about an entity that was policing themselves, and so the very first regulatory function that was removed from the Bar Association was back in the 90s. So when the Bar Association was coming to the court asking for MCLE, the court didn't want to have that same concern about an entity policing themselves when it comes to CLE. And if you're going to be offering CLE, it didn't seem to make sense to also be approving other entities to offer it. There was sort of an inherent conflict there, and so the court expanded that regulatory role of the court with respect to the profession and gave MCLE to judicial branch education, which actually was what I was doing. So I expanded my role of teaching, arranging for the education of judges, to include oversight of MCLE compliance and approving entities to offer CLE to our attorneys in Nebraska. Then in 2013, so we fast forward 6 years or so, a state senator came forward with a federal petition saying that it was an antitrust violation to have the Bar Association be mandatory in the state of Nebraska.
No names are available.
We were one of the early states that took on that concern, and the state senator also filed a petition for a rule change with the Supreme Court, asking that the Supreme Court decommission the mandatory nature of the bar, essentially is what he was doing. The federal court put on hold its ruling in Senator Lautenbach's petition in federal court, pending the Supreme Court's ruling on his petition to change the nature of the Bar Association. They treated that petition in the Supreme Court like a court case. They scheduled it for oral argument. The NSBA filed an objection to any change in the nature of the mandatory bar, and the court asked NSBA, what do you want? And they said, we want to stay the way we are. And pretty much the court said, that's not looking good, so do you want to be a mandatory bar with the court doing the regulatory function, or do you want to be a voluntary bar? And they really never addressed that issue. The court itself was concerned about 23 statutes in the state of Nebraska that required bar admission for an attorney to do something. Like if you're going to serve on certain boards, you have to be a member of the State Bar Association. If you want to get an appointment as a public defender, you have to be a member of the State Bar Association. And that was a big concern that I think drove their ruling that we are going to remain mandatory to the extent the attorneys must belong to the State Bar Association, but we're going to take all the regulatory functions and only require the payment of mandatory dues. So in Nebraska, to be an active lawyer, you pay $98 a year, and that's all you have to pay. But if you want the benefits of the Bar Association and want to take part in the things they do, you get a reduction in your rate of CLE payment, then of the things they offer, then you also pay $240 voluntary dues. So that's how we got where we are today, with a mandatory Bar Association with not mandatory dues for the benefits of the Bar Association.
I'm sorry.
And I
Thank
feel
you.
like I'm not maybe connected.
Carol, is there more you wanted to say right now, or are you ready for questions?
I can kind of describe the experience that this led to, or I could take questions, whichever you prefer.
I think, why don't you tell us about the experience, because that might prompt or inform additional questions based on what you've already shared with us.
But that would be fine. What happened next then was conversations about, okay, how are you going to do admissions? The things that the court brought over in their opinion are things the court itself identified as regulatory, which was the admissions process of the giving of the bar exam and overseeing character and fitness investigations for new admissions, license renewal, annual license renewal. Of course, discipline and MCLE were already there within the court, and UPL was brought over. What we did is look around at how other courts were overseeing all of the regulatory functions, and what we did is create the Attorney Services Division of the Supreme Court. So we used to be MCLE, now we became the Attorney Services Division. The court,
Carol, you're kind of cutting in and out, and I'm not sure if it's your phone or our technology. So perhaps if you could speak a tiny bit louder and a tiny bit slower, we would be able to more fully understand what you're saying.
I will sure do that, and let me know if there's things that you need repeated.
That's significantly better already.
Okay. We created this division of the Supreme Court, and some states, like Iowa, who has the same model we do, they called their division the Professional Regulatory Division. We wanted to be more service to attorneys oriented, so we're the Attorney Services Division. The first thing the court did is express concern about the next bar exam, which was scheduled for the following July. And the Bar Association was saying, why don't you let us administer that bar exam? And I'm kind of saying, no, we know how to do it. Let's bring it over now. I was concerned about the integrity of the bar exam, and there was a lot of hard feelings about pulling these things away from the Bar Association. The court ended up letting the Bar Association administer that July exam, and then they published incorrect results. So 6 people that thought they passed were told they flunked, and 6 people that thought that they had flunked were told they passed. And it was an absolute mess. And I don't think the court understood how deep the hard feelings were being felt. And not to say that the bar exam was compromised because of that, but there was not the oversight that should have been of the bar exam. And so it's important, I think, to make the change complete before things like the bar exam takes place. The Bar Association ended up laying off 19 people when the licensure and admissions process was taken away. That really was their ability to sustain a lot of positions. The Supreme Court is a completely paperless, computer-driven admissions and relicensure system. So we took on 2 positions, and they laid off 19 in doing those things that we did take on. The court left behind the Client Security Fund, which is client protection funds in a lot of states. It left behind the Lawyers Assistance Program, and it left behind IOLTA within the Bar Association. And they contract with the Bar Association for those things that they identified as non-regulatory, and that's caused some issues and concerns through the years. The National Lawyers Assistance folks had encouraged the court to consider lawyers' assistance regulatory, and it declined to do that. So there's a split there that causes us to not have as easy access in the admissions process to the Lawyers Assistance Program. So there's been some split in opinion about what regulatory functions are. So that's caused some issues through the years. The biggest problem we had in this was with attorneys not paying attention and realizing that there are now two dues structures in Nebraska. So attorneys that pay the Bar Association, like they always have in the past, think they hold a license when they don't. If that's all they've done is pay the Bar Association, then they don't. They end up on our list of suspended attorneys, and then they become concerned. So the very first year, we ended up refunding $36,000 in late fees for attorneys that had only paid the State Bar Association, had never logged in, and paid their mandatory $98. So they get correspondence that you are now in a late fee period, and to renew their license, they have to log in and pay that fee. And the court ended up having so many complaints that we went through and refunded lots and lots of late fee payments that first year. We still, 6 years later, get attorneys that say, I paid my dues. What do you mean I have not renewed my license? So it takes years for attorneys to make a big change, especially if they've been practicing a long time, and to, on top of that, require an online process has been confusing for attorneys, unfortunately. I'm going to pause a minute to make sure I'm being heard better and everybody's able to hear me.
Eileen, please.
Could you repeat just the fee structure? It broke up just as you were describing it, and I'm afraid I didn't get it.
Okay. The Attorney Services Division, or the fee structure, okay. Always, the State Bar Association sent out their annual bill, and it was like $360 to be an active attorney in Nebraska. They didn't alter the look of that fee statement. But what the court did is say from now on, $98 of what the Bar Association used to charge is going to be considered the mandatory dues, and that pays for the regulatory functions. So it reduced how much NSBA could charge for their voluntary dues by $98. So out of an attorney's pocket, if they want to pay the voluntary dues, it still costs them that same amount that it used to, $300-some. But now they pay the court $98, and they pay the balance on that due statement that NSBA sends out. And that's sort of what generates the confusion with attorneys. Always in the past, they paid on that same due statement. They're still paying it. Why didn't that renew my license? Did that explain it?
So did the bar keep the money that was supposed to go to the court, or was the bar going to send the money to the court? Or was the attorney supposed to write two different checks?
Some attorneys did continue to pay that $300-some. Some just paid the amount on the bottom of the statement, thinking, oh, that's all it's ever been. The ones that paid the extra amount, we saw it both ways. Sometimes we don't know always what happened. Sometimes we got a check for $98 from the Bar Association saying, Joe Smith paid us instead of you. Well, the problem is our online system, it won't issue you a license unless you log in and pay that $98. So we then had to deal with Mr. Smith about the fact you paid the wrong entity. Here's your $98 back. So it caused a lot of issues. When people paid the extra money to NSBA, we couldn't accept it that way. So either NSBA had to refund the whole thing and make them start all over. And we never had a plan in advance of how we were going to handle that, not realizing a lot of the things that did happen were going to happen. So it was just handled case by case. But that is something that's good to be aware of, that attorneys may just pay the full amount to the bar.
So
Thank
it sounds like that would be a lesson learned, as well as a couple of others that have come up so far. Paul Swagel, a work group member, has a question for you.
Hi, and thank you for participating in today's meeting. What is the entity that remains as the Bar Association? Is that an association. What's the legal entity and how is it governed?
The Nebraska State Bar Association is just a private association that exists because of Supreme Court rule that authorized them to be the mandatory association way back when. So they have their own board of governors. That it's outlined in Supreme Court rule how it functions. It functions independently with its board of governors.
So it sounds like your cell phone signal is breaking up. Can you maybe move a couple feet one way or the other, get us a better signal?
Yes, I think we'll change positions here. Able to hear that about the Bar Association?
If you'd repeat it again, I think that would be helpful.
The Bar Association was created years and years ago, like early 1900s, as a Supreme Court rule-generated independent association with its own board of governors. The court rule does authorize how the president gets elected, but it is an independent association with its own structure for budgeting. They do report to the court annually on how their budget is used.
And now that you have both sort of the mandatory and the voluntary, what continues to be the Nebraska State Bar Association's role? And did it change how it was governed, or did the court rule change? What sort of, historically, that's what it was, but what, if in any ways, is it different now?
It, I think, has at least attempted to redefine its role. The court didn't give them any path other than to say you're no longer going to do admissions or licensure or UPL. So it has always been the entity that offers CLE, both before CLE was mandatory and now. It had a role in the Volunteer Lawyers Project and in help desks. And one of the early things it did is terminate.
No names are available.
Because of the lack of revenue that it felt that it needed to run the help desks. So they do have a role in assisting pro se litigants, but it did become a diminished role. I think that the Bar Association had really dedicated itself to those mandatory functions of the bar exam and the licensure. And it always also had a role in supporting the profession, but it's had to really build that part of its mission since it isn't doing those other ministerial functions. So it has continually looked to how do we find our relevant role now.
Is it still considered a Supreme Court rule authorized entity, and just some aspects of it were pulled into the what you call the mandatory aspects were pulled in under the Supreme Court under your Attorney Services Division, but the rest continued as it was before?
That's right.
Okay.
And that's what its voluntary dues supports, are those other aspects of its mission.
Lose its sort of status as the Nebraska State Bar Association and become, in essence, just but became more like we have here, county bar associations or specialty bar associations. Am I correct
Yes,
in
there are
understanding
still,
that? I mean, you still have the
yes,
others.
although when the Supreme Court is going to undertake a study, it does defer more to NSBA, like should we change the cut score for the bar exam. It will have NSBA undertake a survey and those sorts of things. So there is a closer link to that bar association because it's statewide than you see typically with the local bar associations. But otherwise, except for that role when the Supreme Court is looking for some input, it will defer to the State Bar Association.
So it really you would say, is operating independently, although authorized by court rule?
Yes.
All right. Is the Supreme Court reviewing the budget or reviewing bylaws or any other aspect of funding or governance of the Nebraska State Bar?
You know, it does get a budget report, and if NSBA wants to change something in their structure, they will file for a rule change because the Supreme Court rules do outline those things. But the court always grants what it asks and has not expressed any concern about budget use.
All right. Do you have a referendum process in Nebraska? A member
Yes.
referendum process?
Yeah, I believe it's in the rules, yes.
Okay. I think it might be helpful for us to get your rules and look at how you've structured it, so it'll be interesting information. Other questions from board members? Hunter Abel, a work group member, has a question.
Good
Carol.
morning. First of all, thank you very much for being with us here today by telephone. We appreciate it. As a quick initial matter, too, I want to say Nebraska has sort of always interested me. In addition to having this unique bar association model, you also have a unicameral legislature and a nonpartisan legislature. So Nebraska is obviously continuing its history of thinking outside the box. And again, this is helpful for us to think about. One question for you, or a couple of questions for you. If I understand correctly, the voluntary bar dues gain access to what you call the Attorney Services Division. Is that correct?
No, the voluntary dues get access to the State Bar Association's benefits of free CLE, their insurance, their casemaker, computer system, or research software. What the $98 is paid to the Attorney Services Division. That's attorney discipline, but we also, because the Supreme Court wants to serve attorneys, within attorney services, we have a huge forms bank that all attorneys get access to. We have the education that qualifies attorneys for appointments like guardian ad litem and public defenders. We do the education that we offer it online that will qualify them for appointments. So the Attorney Services Division is the Supreme Court. It satisfies your regulatory duties and offers you some practice things. We also give some CLE to attorneys on those things that the Supreme Court mandates they know.
Thank you. So I obviously had that backwards. So the $98 gains you access to the Attorney Services Division, which is part of the Supreme Court. Is that correct?
Yes.
To practice law.
Right.
And it is where your discipline would happen, or as Carol was explaining, where they would offer some education for things that you're required to be an attorney to serve on boards or commissions in Nebraska. So it would be, I think, what we have when we look at sort of, we're deciding what's, quote, thinking about what's regulatory and what's non-regulatory. And what I hear Carol saying is that in Nebraska, what they consider regulatory, truly regulatory, they have pulled in underneath the Nebraska judicial branch. And what they have left standing is everything else that was the State Bar Association without the regulatory. And they've split their annual dues of around $360, and they've pulled $98 to pay for what the judicial branch is doing, and they've left $262, about, guessing whatever the number is, for the Bar Association to do everything it was doing without the regulatory now.
Got it.
So that's that. Am I correct, Carol? Have I captured your, synthesized or synopsized your sort of bottom line big picture?
Yes, very much so.
I'm going to go to Andrea Jarman from the work group and then to Eileen Fairley. Now, Andrea.
Thank you, ma'am. I'm wondering if your bar association previously had any diversity and inclusion programming, and whether or not any portion of that was determined to be regulatory.
It wasn't regulatory. We had the Minority Justice Commission, and the Bar Association took a lead role in running that commission. It had members of the court on it, and it had attorneys on it. That's one of the things the bar backed off on when the court took away the regulatory functions. it stopped running the Minority Justice Commission, and the court revived it as a Supreme Court commission and included the Bar Association in it. But it's a much more robust commission now than it was when the Bar Association took the lead with it. So that unfortunately did go away for a year or two until the court took it on. But it's not really part of attorney services. It's a Supreme Court commission.
Thank you, Eileen.
Thank you, and thank you for taking the time to speak with us. I have three sort of linked questions, and maybe to follow up on Andrea's. Between the mandatory bar and the voluntary bar, did people pretty much stay in both, or did the voluntary bar shrink, basically? Is there a big difference in size between the mandatory and the voluntary?
Not a big difference. There was about a 25% reduction at first. That first year, I think their membership rate was 75% of licensed attorneys, where it had been obviously 100% in the past. That has inched up. It's still under 80%, and we don't always get annual updates from NSBA on where they are at in their membership, but it has hovered somewhere between 70 and 80, I believe.
And to follow up, you had mentioned that the, not attorney services, but the lawyer assistance program had been, your court took the position it was not regulatory. The National Association took a different perspective. What was the analytical approach your court took to determine what was regulatory versus what wasn't?
That was done in the decision-making process of the actual opinion rendered. So it's not like any of us knows that. I've heard at different times, different of the justices disagree about that. So I think it wasn't well, for one thing, I don't think the court knew much about the lawyer's assistance program. And we have done some education on these programs, and I don't know that it will always stay at the bar. I think the court is sort of considering and looking at the possibility of bringing that in. But I think that it wasn't big on their list of things they were aware of in terms of things the bar did at the time the opinion was rendered. I think that the obvious things are the licensure, the education. UPL is sort of on the Supreme Court's radar. So I just think they didn't have a lot of information on that, and that's what we ended up with.
And just one last follow-up question. With the new Supreme Court Commission on Diversity and Inclusion, how is that funded?
In fact, I wrote a grant through SJI initially that was a generous grant that we got. Since then, we've looked at various things to do. I was advocating for CLE late fees and licensure late fees to be dedicated to that. And the court's been receptive to those suggestions. So each year, of course, we look for how are we going to fund it. And we have gotten a renewed grant on one occasion. So I think the use of late fees is a really good way. The MCLE fees itself and licensure fees itself are directed within the rules to things that money is meant to support. The late fees just is meant to support the practice of law. And it's kind of, at least my position, that late fees being used for minority justice issues and pro se issues is a very good way to support the practice of law.
Carol, we have a very robust access to justice community and board that is currently in our State Bar Association. How has Nebraska dealt with that issue? New arrangement.
I don't think that it was a high priority of NSBA before. I think the Supreme Court Minority Justice Commission, which does have a subcommittee on access to justice. Again, I think they're doing a better job of access to justice issues, kind of looking for ways to support pro se litigants. And they're very good about looking at trends and concerns that are raised in access to justice.
One other question I have, and then I'll go to another one of our work group members, is in Washington we have several Supreme Court appointed boards that are housed at our Washington State Bar Association, and we also have Supreme Court commissions that are funded by the legislature. For example, we have a Minority and Justice Commission, a Gender and Justice Commission, an Interpreter Commission, a Commission on Children in Foster Care. So we have sort of already a split between what the court's sort of involved with and running and what the court has asked the bar to manage and administer with attorney due funds. And so do you have any experience or suggestions in that area, or do you have something similar to that in Nebraska?
Our court certainly never directed NSDA to take part in access to justice or pro se issues or any of those things. And when they took away the regulatory functions, the bar took the position that it didn't have the resources to become engaged in those things, and that got pushed away a little bit. So the court really has had to take those things on itself. I think that if you've got a bar association that is doing great in those areas, that's wonderful. But our court really has had to step up and take the role in a lot of that.
Next, I have Esperanza. I am sensitive that we have used the allotted time that we asked you to be with us. We do have a speaker following you, so I'd like to perhaps have Esperanza ask a question. And then, Carol, I would ask if the board, or the work group has additional questions. Would you be able to make yourself available at a future meeting, perhaps, or have us send you our written questions to get your response?
Sure, either way would be fine. Yep.
Okay. I don't want to cut us short, but I want to be sensitive to our speakers. Esperanza, please.
Yes, thank you very much. Thank you very much for all the information as well. But I'd like to know, is there any information or data showing the impact of these changes to the bar to communities who are challenged in their efforts to gain access to justice?
We really haven't done any inquiry in that regard. We know what it's like from the perspective of the judges, who really liked having the help desk, and those went away for a while, and now they are set up again. So I'm sure there was some things that were inconvenient and difficult caused by this early on. I think we've worked hard to at least make up for the losses and probably offer better services just because it's become so necessary with our self-represented population.
Any final questions from work group members? Having sort of laid down we're out of timeline. All right. With that, Carol, I would like to thank you very much for making yourself available. And I found, and I'm sure the work group members found, your model and your approach very interesting and helpful for us as we think about the recommendations that we're going to make to the Supreme Court about how we move forward in Washington. So thank you again. We really, really appreciate it. And we'll be gathering your rules and different information so we can actually see structurally how you have done it. So thank you again.
Sure. Let me know anything I can do for you.
Thank you, Carol.